Greetings from National Resource Center, Shri Ram College of Commerce, University of Delhi. Ignorance of law is no excuse. In the spirit of this maxim, the objective of this session is to acquaint you with a much talked about law these days, that is Insolvency and Bankruptcy Code 2016. I will be frequently referring to it as IBC or code in the following discussion. After reflecting upon the background behind enactment of IBC, the legal framework of the code will be discussed. Session will conclude with a critical analysis of the implementation aspects of this code since its enactment. Now, before starting a discussion on IBC, it is very crucial to understand the difference between insolvency and bankruptcy. The two terms are often confused to mean the same thing, but that is not the case. The two terms are not synonymous. In fact, they represent two different phenomena. While insolvency refers to a state of economic distress, bankruptcy is a court order that declares a person or an entity as insolvent. In simple words, insolvency is a situation where any person or an entity is unable to repay its outstanding dues. On the other hand, bankruptcy is a situation where a person or an entity is legally declared as insolvent. Bankruptcy order decides how an insolvent debtor will deal with its unpaid obligations, which usually involves selling the assets to pay off the creditors and erasing the debts that cannot be paid. Thus, it can be said that insolvency is a state of affairs which triggers the legal process of bankruptcy. It is also important to note that while this distinction is relevant for most of the countries around the world, in England and Wales the position is slightly different. There, the distinction between insolvency and bankruptcy is determined by the nature of the entity. That is, if the entity is a body corporate, it is governed by the insolvency regime, while if it is an individual, it is governed by the bankruptcy regime. Now, having understood the essence of insolvency and bankruptcy, let us discuss about Insolvency and Bankruptcy Code 2016. IBC came into effect from December 2016. Now, the year of enactment of IBC, that is the year 2016, may raise a question in our mind that what used to prevail before the introduction of IBC in India? Was there any law existing in India to govern the insolvencies before the introduction of IBC? And the answer to this question is yes. Yes, various laws have been passed since independence to deal with the insolvency and bankruptcy cases in India. In fact, there used to exist different laws to govern the insolvency of different type of entities in India. For instance, insolvency of individuals was dealt with under the Provincial Insolvency Act 1920. For partnerships, insolvency and bankruptcy process was framed under Indian Partnership Act 1932. Insolvency of LLPs was governed by LLP Act 2008, and finally, for the insolvency of the companies, there used to exist multiple pieces of legislations to deal with it. Firstly, there was Companies Act 1956, which was later replaced by Companies Act 2013, which governed the insolvency and winding up of a company. Then, in 1985, in an era of industrial failures, Sick Industrial Companies Act was also enacted in order to help bail out sick and beleaguered industries. Additionally, Recovery of Debts Due to Banks or Financial Institutions Act 1993 and the SAFESI Act 2002 were enacted in post-liberalization era to grant special rights to the banks and other secured creditors for recovery of debts. Now, Due to the existence of the varied legislation to deal with insolvency of companies, partnerships and individuals, several institutions have had jurisdiction over the insolvency and bankruptcy process. The Company Law Board, the High Courts, the Debt Recovery Tribunals and the Board of Industrial and Financial Reconstruction dealt with the insolvency of entities they governed. This entire framework made the India's insolvency and bankruptcy structure overlapping, intricate and very complicated, which in turn led to the problem of systemic delays. It took companies 4 to 5 years to dissolve their operations. Not only that, the Sikh Industrial Companies Act, the Recovery Act and the SARFAESI Act, which were enacted to improve the debt recovery process, could not produce the desired results. It is a widely known fact that Indian banking industry is poised with huge cachet of non-performing loans. Thus, a need was felt to devise an efficient and consolidated insolvency law that can bring in stability in the Indian financial system. As also, the Provincial Insolvency Act 1920, which dealt with individual insolvency, was nearly a century old and have not been revamped to suit the present needs. All this necessitated the need for a consolidated legal framework to deal with insolvency and bankruptcy and to improve the debt management in the country, thus leading to the introduction of Insolvency and Bankruptcy Code 2016. The code has been introduced with an objective to address the structural problems which were hampering the efficient recycling of capital. It also seeks to rebalance the rights of creditors by giving them the much needed remedy to take timely and effective action against defaulting borrowers.
As it has already been discussed earlier, the Insolvency and Bankruptcy Code has been implemented with an aim to consolidate insolvency and bankruptcy laws in India and addressing the issue of NPAs which are plaguing the economy. While the work for new insolvency laws was in place for many years, but the insolvency reforms finally took shape with the enactment of the Insolvency and Bankruptcy Code 2016 on 20th May 2016, the day when it received the President's assent. The Insolvency and Bankruptcy Code, referred to as IBC or Code, took 6 more months to become active, and the Act finally became functional from 1st December 2016. So far, we have discussed the background and rationale for introducing this Act. In this section of the module, we will be discussing IBC, the Act itself in greater details. Specifically, we will be discussing the key features of the code, the process undertaken for the insolvency resolution and liquidation, and the recent amendments that have been undertaken to improve the efficacy of the code. The question that might come to your mind is that when already there were so many laws dealing with insolvency and bankruptcy, what was the objective behind this code? The answer to this question is given in the opening paragraph of the code itself, which lays down its objective. The primary objective is to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms and individuals in a time-bound manner. What do we mean by insolvency resolution process is something that we will be taking up later in the module. The second order objective is maximization of value of assets of the firm, and the third order objective is promoting entrepreneurship, availability of credit and balancing the interest of all its stakeholders. This order of objectives is sacrosanct. The word resolution means to resolve the insolvency of the borrower. Now let us try and understand some basic aspects of the code. Overall, the code has 255 sections which has been divided in 5 parts, which are as follows. Part 1 is preliminary, which basically includes definitions. Part 2 relates to corporate insolvency, where the insolvency matters of individuals and partnership firm is taken up in Part 3. Part 4 talks about regulation aspects of insolvency professionals, agencies and information utilities, and Part 5 deals with the miscellaneous aspects of the Act. This code is applicable to companies, limited liability partnership, any other body corporate which may be notified by the central government. It is also applicable to personal guarantors to corporate debtors, partnership firms and proprietorship firms and individuals. It is also important to note that the code is not applicable to corporate entities who are regulated financial service providers like banks, financial institutions and insurance companies. Since the provisions relating to partnership firms and individuals are yet to be notified by the central government, the discussions under this module is limited to corporate entities, namely companies and LLPs. This code has been a path-breaking law and has opened a new chapter in the history of insolvency laws in India. Prior to the enactment of the code, India did not have any experience of a proactive, incentive-compliant, market-led and time-bound insolvency law. Since the code has been first of its kind, let us now talk about some of its key features. The first feature is that it is a consolidated law for insolvency. Unlike the earlier approach, where the insolvency and bankruptcy matters were dealt under different laws, the present code puts all the laws relating to insolvency and bankruptcy under one umbrella. It also provides for a time-bound process to resolve insolvency. With an initial time of 180 days and additional 90 days, IBC aims to resolve the insolvency within a time-bound manner of maximum 270 days. However, through an amendment in 2019, this time period has been increased to 330 days. How strict is this deadline? Think. To emphasize the importance of this deadline, let me tell you that if insolvency cannot be resolved within the stipulated time, the company goes into liquidation, which is to say that the assets of the borrower may be sold to repay its creditors. Another feature is that this focus on a creditor-driven insolvency process by making a paradigm shift from the earlier regime of debtor in possession to creditor in control. What do we mean by this? Well, this means that unlike in the past where the insolvent company itself took control of the assets under the proceedings of liquidation, under IBC this control is now put in the hands of creditors. Any resolution plan can now only be implemented with the approval of insolvent company's creditors. Maximization of value of assets by ensuring a time-bound and quick reorganization and resolution process is another key feature. Prior to this code, the time taken for liquidation was very long, thereby resulting in the erosion in the value of assets. Consider if a company having an assets worth say 100 crores has filed for insolvency in the year 2012. The decision on it under erstwhile multiple law framework came in year 2016. Now what happens because of this is that the value of the assets decline. Let's say if the value of the land crash, machinery and other assets depreciate and the assets value is now let's say only 60 crores. The creditors in 2012 could get 100 crores but will now be left only with 60 crores, leading to an erosion in the value of assets. This long delay has been taken care under IBC. If a case for insolvency is filed under IBC in 2017, the decision on it must come in 2017. The speedy resolution process makes sure that the creditors like banks recover their debts quickly and at a higher value, thus freeing the scarce capital which can be invested in other ventures. This entire mechanism of speedy debt recovery is also vital to promote entrepreneurship, because the entrepreneurs are now assured of easy and quick exit under IBC rather than caught up in long court cases. There are also restrictions of participation in resolution process by defaulting promoters. In the absence of such restrictions earlier, promoters used to bid for their businesses in an attempt to retrieve them at a heavy discount and start afresh with a clean balance sheet. As this is clearly not the intent of IBC, suitable amendments were made, after which it is extremely difficult for defaulting promoters to participate in the resolution process of the corporate debtor. Last but not the least, the overall focus of the code is on revival or resolution rather than liquidation of the corporate entities. Earlier, if the company defaulted in the payment of its debts, then under the Companies Act, it could directly file for winding up. But under IBC, a second chance is given to the defaulting company to revive itself. The current Finance Minister, Ms. Nirmala Sitharaman, also made it clear that the IBC was not looking to force companies into liquidation, but focused on their revival and continuation as going concerns. She said, and I quote, "Not allowing companies to die is the spirit behind IBC. If there is any prospect of company getting revived, the solution is not to go to liquidation, but ensure it is as a going concern. When a corporate debtor is brought back into business through a successful resolution plan, availability of credit with banks and financial institution gets a major boost. Thus, it is expected that IBC will go a long way in strengthening the credit markets." Any law for its effective implementation has to have an effective institutional framework. The code therefore aims at creating a dedicated infrastructure to perform the task as envisioned under it. There are 4 pillars of supporting institutional infrastructure to make the insolvency and bankruptcy process work efficiently. Talking about this framework, at the top there is Insolvency and Bankruptcy Board of India, in short IBBI, established on 1st October 2016. It has been set up as a regulator to oversee functioning of entities created under the code, namely insolvency professionals agencies, insolvency professionals and information utilities. This board is also entrusted with the task of overseeing the insolvency proceedings in the country. To understand the importance of IBBI in the insolvency framework, it can be equated with the role that RBI plays in the banking sector and SEBI in the securities market. The board has 10 members, which includes a chairman and representatives from RBI, Ministry of Finance, Corporate Affairs and Law. The next level of hierarchy in this institutional framework is the Insolvency Professional Agencies or IPAs. The insolvency professionals or IPs have to be registered with IPAs. The IPAs conduct examinations, enforce a code of conduct for their functioning. Currently, there are 3 IPAs registered with IBBI, namely the Institute of Chartered Accountants of India, Institute of Company Secretaries of India and Institute of Cost and Work Accountants of India. The heart of the entire insolvency process lies in the functioning of IPs, who are specialized cadre of certified professionals. The IPs will conduct the insolvency resolution process, take over the management of the company, control the assets of the company, assist creditors in the collection of relevant information. And if the company fails to revive, they will become liquidators and manage the liquidation process. These insolvency professionals have to be registered with IPAs. Now, who can become an IP? Advocates, chartered accountants, company secretaries, cost accountants having 10 years of experience in their respective fields and of course having passed the insolvency examination can act as IPs. Even graduates having 15 years of experience are also eligible to become IPs. Entities like LLPs, partnership firms or even a company can also be registered as IP provided majority of their partners or whole-time directors are registered as IPs. A key innovation of IBC framework is a new industry of information utilities. Information utilities store facts about lenders and terms of lending in electronic databases. Information utilities are set up to collect, collate and disseminate financial information related to debtors. Such information is to be collected from creditors and include records of debt, liabilities and defaults of a debtor. The concept of IUs will be the same as CIBIL scores in the context of individuals. Like CIBIL scores talk about the credit history of an individual, IUs will do the same for the corporate debtors. National e-governance is the first and only information utility to be registered till now. The backbone of the law lies in its effective implementation through judiciary system. The court has two adjudicating authorities for this purpose. The function of these authorities, of course, in addition to the interpretation of the court, is to evaluate applications for initiating insolvency proceedings, approve appointment of IPs and approve resolution plans. The National Company Law Tribunal NCLT is the adjudicating authority for companies and LLPs. Appeals against its orders is heard by National Company Law Appellate Tribunal referred to as NCLAT. The Debt Recovery Tribunal will adjudicate cases for individuals and partnership firms. Appeal against its orders will be heard by the Debt Recovery Appellate Tribunal. The task of these adjudicating authorities becomes even more challenging in the absence of judicial precedences. Having discussed the background of the code and before going forward to comprehend the process of corporate insolvency resolution, it is important to understand several key definitions relating to corporate insolvency resolution process referred to as CIRP. The knowledge of these concepts will facilitate our understanding of the CIRP. Some of the keywords are debt. What does debt mean? Debt means a liability or obligation in respect of a claim which is due from any person and includes a financial debt and operational debt. However, the mere existence of debt does not lead to initiation of the resolution process. There has to be an existence of default. Now, what is default? Default in simple terms is non-payment of debt when it has become due and payable and is actually not paid by the corporate debtor. The earlier laws like Companies Act did not make any distinction between creditors. The creditors were either secured or unsecured. The IBC makes a clear distinction among creditors by classifying them as financial creditors and operational creditors. To understand the concept of financial and operational creditors, let us first discuss what is a financial debt and operational debt. Financial debt means a debt along with interest, if any, which is disbursed against the consideration for the time value of money, such as money borrowed against the payment of interest or any amount raised to the issue of bonds, debentures, etc. Financial creditor means any person to whom financial debt is owed. Operational debt means a debt due in respect of the provision of goods or services supplied to the corporate entity like raw material, includes any amount to be paid to employees or a debt in respect of payment to any government, be it central, state or local. Operational creditor means a person to whom an operational debt is owed. Let us take an example to appreciate the distinction between financial creditors and operational creditors. Consider a situation where a person decides to open a restaurant. He takes a loan from a bank to buy the property for the restaurant using the property premises as the collateral. His friend lends him some funds to manage the initial expenses such as payment of salary to chefs and other support staff, buying raw material, etc. In this example, the bank and the friend are financial creditors. The bank is a secured financial creditor since the loan is backed by a collateral, and friend is an unsecured creditor. The chefs and staff at the restaurant, the supplier of raw material, are operational creditors. While discussing the process of insolvency resolution, we will come across usage of terms such as corporate debtor, interim resolution professional, resolution plan, etc. Let us now make an attempt to comprehend these terms. Firstly, the corporate debtor means a corporate person who owes a debt to any person. The interim resolution professional or IRP is the insolvency professional whose name is proposed by the resolution applicant. That is the person who is filing a petition with the NCLT to initiate the CIRP. He is to hold office from the date of such appointment till the date of appointment of a final resolution professional by committee of creditors. The IRP or a different person may be appointed as a resolution professional. Resolution professional means an insolvency professional appointed to conduct the CIRP and includes an IRP. He is appointed by the committee of creditors in its first meeting. As mentioned earlier, either the interim resolution professional or any other IP may be appointed as resolution professional. Resolution plan. It means a plan proposed by resolution applicant for insolvency resolution of the corporate debtor as a going concern. Resolution applicant means a person who individually or jointly with any other person submits a resolution plan to the invitation made. Another term is moratorium period. It is the period during which no action can be taken against the corporate debtor. In simple words, no legal proceedings can be initiated in the court of law against the corporate debtor during this period. There are two dates also which are important in the CIRP, the initiation date and the insolvency commencement date. Initiation date means the date on which a financial creditor, operational creditor or corporate applicant, as the case may be, makes an application to the NCLT for initiating CIRP. It is the date on which the petition for insolvency is filed with the NCLT. Insolvency commencement date means the date on which the said petition is accepted by the NCLT.